It is captioned as compensation for breach of contract. Section 73 of the Indian Contract Act provides as under: where a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation. So firstly, it provides that a compensation is payable. The party who suffers the breach is entitled, means the party who suffers the breach has a right to receive compensation from the other party. How much compensation? And for what? Compensation is for loss or damage caused to him. So first condition to be noted is there must be some loss or damage caused to the first party, which also means that if there is no loss or damage, then no compensation, because compensation is not in abstract terms, not in vacuum. Compensation is only for a loss or damage caused to the first party by the breach caused by the second party. Clear? So there must be some loss, some damage, and it is only for compensating that loss. Now, compensation is to be computed how? The loss or damage which naturally arose in the usual course of things from such breach, which is the natural consequence of this breach. Whatever loss is caused to a party in the natural course of events whenever such breach is there, or when parties knew at the time of making the contract that this loss or damage is likely to result from this breach. So if both parties knew at the time when they entered into the contract that in case of breach, this is the loss which is likely to be incurred by the other party, then that much loss will be computed and that will be awarded as compensation. You will see that these provisions, this language is very much similar to the language used by the court in the case which we just did, Hadley versus Baxendale. Same language has been employed. We can say that section 73 is entirely based upon the judgment given in Hadley versus Baxendale.